Good morning, and welcome to today's webcast, COVID-19 Stimulus Funding, Impacts and Benefits for Tribes. As a reminder, the material appearing in this presentation is for informational purposes only and should not be construed as advice of any kind, including, without limitation, legal, accounting, or investment advice. This information is not intended to create, and receipt does not constitute a legal relationship, including but not limited to an accountant-client relationship. Although this information may have been prepared by professionals, it should not be used as a substitute for professional services. If legal, accounting, investment, or other professional advice is required, the services of a professional should be sought. We have a lot of information to share with you today, but we'll try to save some time at the end of the webcast to answer your questions. To ask our presenters a question, please type it in the Q&A window and hit submit. If we don't have time to answer your question, we'll follow up with you after the webcast. Finally, in addition to today's presentation, Moss Adams has many resources to help you navigate COVID-19. You can find links to these resources in the slide deck and handout widget to the left of the slide view. Before we begin today's presentation, I'd like to turn it over to Tasha Rep, Partner and National Practice Leader of Moss Adams Tribal and Gaming National Practice. Tasha?
Thank you, Pam, and good day to you all. I hope this message finds you well. We know that each tribe has been impacted by the results of the coronavirus pandemic. The financial and health impacts being responded to by tribes has been significant, and although some support has been provided by the federal government, for many tribes, it is not enough. Additionally, the regulations around these programs are complex, and tribal eligibility for many of these programs is complicated or unclear. We will continue to share and provide our insights and guidance on these programs as we learn more, and as always, are here to support you. We hope you and your citizens remain strong and healthy. Shah. Now, I'd like to welcome today's presenters. Anita Shah and Ryan Leutkemeyer are senior managers in our Moss Adams Tribal Services Group. Ryan has been working with tribal governments for nearly 20 years, and Anita has been working with tribes since 2008. They both exclusively work with tribes and are key members of our tribal services team. Additionally, joining them today is Rebecca Patterson, a partner with Sonosky. Sonosky is a national rights law firm with offices in Alaska, Washington, D.C., New Mexico, and California. Becca joined the firm's Anchorage office in 2013 and primarily focuses on assisting tribes and tribal organizations. And now, I'd like to turn it over to Anita to get us started with today's webcast.
Thanks, Tasha, and we echo her message of wishing everyone health and safety. We'll start our presentation talking about the coronavirus relief funds. You know, the $8 billion pot that was set aside in the CARES Act for tribes. As everyone is probably aware, Treasury provided guidance on the use of these funds, so we'll go over that guidance. Then we'll talk about how to maximize the funding options available in form of tax credits and loans that are available to tribal governments, casinos, and other tribal businesses. Lastly, we'll briefly discuss the accounting matters related to this funding. With that, I'll have Ryan start out with our coronavirus relief fund.
Thanks, Anita. I do want to get started right away talking about what you guys might have seen from the April 22nd guidance from the Treasury Department. The CARES Act provided three broad categories of allowable cost criteria for how to use these funds. And under the first criteria, which we list here, for necessary expenditures incurred due to the public health emergency, the Treasury has determined that these items that we have summarized essentially in these bullets meet this requirement. Okay, so the first two bullets that the Treasury essentially is saying here it's pretty obvious and understandable, right? So the expenditures are reasonable, and then on the second bullet, that the costs are used to respond to this emergency. That's pretty cut and dry. Now, when we get to the third and fourth bullet in this slide here, essentially what it's saying is that you could use the CRF money to provide economic support to those suffering from employment or business interruptions due to the required closures. All have suffered as a result of this pandemic. So many tribes interpret this as providing assistance payments directly to tribal members as an allowable cost to meet this requirement. So again, that's it's a bit unclear, but that's how we hear from tribes is what they're interpreting that to mean. Now, the fourth bullet that we have here on the slide, the funds are not intended to be revenue replacement. Now, given the inconsistency between allowing business interruption assistance but not allowing revenue shortfalls, we're going to talk a little bit more with Rebecca about this and how we can square that circle. So on this next slide here, let's look at the next broad category for allowable costs under the CARES Act. Essentially, the CARES Act is saying that the costs are not accounted for in the budget most recently approved as of March 27th, and it does not take into account subsequent appropriations or adjustments to respond to the COVID crisis. Now, what Treasury is essentially saying here is that, and the concern might be that many tribes, if you've budgeted the cost before 3/27, many tribes view this as the cost might not be allowable to use for CRF reimbursement. However, the two things to key on, first, let's focus in on the cost if it cannot be lawfully funded by the allotment in the original budget. Let's focus in on that criteria. Some tribes have indicated that in their original budget for the allocations under their revenue allocation plan, to fund general government, economic development, and housing through gaming distributions, those costs essentially now have to be rebudgeted since they're no longer to be funded through gaming distributions. And so as a result, some tribes are viewing this as allowable costs now to fund through the CRF distribution, because now it has to be rebudgeted and you have to consider new allotments to fund those expenditures. And the second bullet, we need to look at that term in the guidance that says substantially different use criteria. I want to get a legal perspective on this. So this particular area, we're going to save to talk a little bit more with Rebecca to provide her an example of what tribes are looking at when they redefine and try to interpret what substantially different use means. So we're going to talk about that a little bit later. But this final criteria that the CARES Act provides here at the bottom is that costs incurred during the period that begins March 1st and ends through December 30th of this year. Essentially, it's quite simply, this is your allowability period for using these funds.
In their guidance, Treasury provided certain examples. Treasury provided certain examples of allowable and unallowable costs. Allowable costs include payroll for employees whose services are substantially dedicated to mitigating or responding to public health emergencies. Treasury hasn't defined the word substantially dedicated, so it appears tribes have flexibility to determine which employees can be paid using these funds. Another positive about the allowable cost guidance is that these funds could be used to get your casinos and other tribal businesses up and running again, and you can support these businesses, in need through the end of this year. The guidance also mentions this government payroll support program, and the only payroll support program that we're aware of is the agreement that Treasury made with the airlines so that airlines can pay their employees during this time. So it does beg the question if a tribe can create a payroll program to support its employees, not only just for the tribal government, but also for the casino and its businesses. The Treasury guidance also specifies that these relief funds could cover costs that aren't covered by the unemployment insurance costs that aren't covered by federal or state government, state grants. So those unemployment insurance costs could be covered in this as well. Treasury provided a shorter list of unallowable costs under this guidance, and most notably, again, is related to payroll costs for employees whose work duties are not substantially dedicated to mitigating or responding to this. So again, it appears that each tribe, this is subject to each tribe's interpretation. So just please make sure you document your thought process on why you consider costs to be charged to these funds. Other unallowable costs include legal settlements, and if costs were covered by another federal program, they wouldn't be allowable to be charged under these, covered by these funds. They also released a short FAQ, and the main ones that I wanted to go over is that tribes will have to return the money that hasn't been spent by December 30th, 2020. They'll have to return those unspent funds to Treasury. And a tribe can transfer these funds to another government, but that other government would have to be spending these funds in accordance with the federal requirements based on the needs under the CARES Act. So it appears that if you as a tribe are transferring funds to another government, you may be subject to the subrecipient monitoring requirements. So just make sure you're documenting that and careful when you're transferring these funds over. And now we'll go over some of these specific questions related to the Treasury guidance to get a legal perspective from Becca. So Becca, as Ryan mentioned, when we think of business interruption in terms of insurance recovery, revenue shortfall is what comes to mind. But this guidance clearly says that revenue shortfalls can't be used for these funds. So in your view, what is the difference between economic support for business interruption versus covering revenue shortfall?
Sure, and before I hop right in, I just want to put two things in there. That this is our perspective on these, and I don't work for Treasury, so Treasury might at some point take a different stance. And Treasury has said that they've had some calls with state and local governments that have received funds from the COVID relief fund, and they understand there's a lot of questions despite their guidance, and so they anticipate releasing a Q&A document sometime next week, hopefully on Monday. So that might shed some light on some of these questions. Now, as to this first question, you're right. In the insurance context, when you think of business interruption, you think loss of income is included in that. But it's important to look at the actual language that Treasury used in the guidance. And that language talks about expenditures related to the provision of grants to small businesses to, and here's the important language, reimburse the cost of business interruption. So I think the idea here is that they're reimbursing your costs to continue operations functioning, to keep the lights on, to pay rent, pay employees. But what they're not taking into account is the profit or the margin, whatever term you want to use, that you might have received if you were operating that business as regularly scheduled. So let's say that you're running a restaurant and that restaurant usually would make $100,000 a month and it costs $60,000 to pay your rent and pay your employees and utilities and everything like that, and your $40,000 there would be your margin. They're not going to pay you that $40,000, but they'll pay you the $60,000 to keep the lights on and keep your employees paid. That's the way I think that they're trying to interpret it here. It's a reimbursement for pretty much what they see as necessary costs. They're not going to reimburse just the shortfall from your regular revenue stream.
That's super helpful. Thank you. So then my next question is about all those other essential workers at tribes that don't always get the recognition they deserve. So, finance and program employees are spending substantial amount of time on COVID-related funding and cash flow projections and whatnot. Would you consider those costs to be allowable per the Treasury's guidance?
So I'm going to go with the classic lawyer response of possibly. And just as a matter of best practices, I would recommend, any employees whose functions have now changed or have split between kind of COVID-related tasks and non-COVID-related tasks to track time spent on COVID matters versus other matters. And the reason I say that is that will help you assess, are they substantially dedicated to mitigating or responding to COVID, right? And so if you have an employee where 95% of their time is still doing their routine tasks and they're only doing COVID stuff for 5% of the time, then you might have a hard time arguing that they're substantially dedicated to responding to the COVID emergency. But on the other hand, if they're spending 75% of their time writing grants for COVID funds or whatever the case may be, then I think you have a much stronger argument. And the Treasury guidance does anticipate that certain administrative employees will fall into this category. So they mention human resources because they know that your HR employees are spending a lot of time answering questions about special types of leave, perhaps working on furloughs, working on writing new policies for interactions with the public, right? A lot of those functions have now become COVID related. And so it really is probably going to be something that you look at on an employee by employee basis to see what are they doing now and is most of their time COVID related.
That's wonderful. This is super helpful guidance. Thanks, Becca. And I believe Ryan now has some questions for you.
Yeah, Becca. So, when I brought up earlier that the guidance defined what costs were allowable in the tribe's original budget, it indicates that such costs could be allowable if, quote, they are a substantially different use from any expected use of funds in such a line item, allotment, or allocation. For those employees who we've budgeted for, right, with their salaries previously, but now are required to stay at home because of, state-ordered mandates, et cetera, could now those salaries be considered allowable and reimbursed through the Title V funding?
So again, I'm going to say possibly. And again, it depends probably on an employee-by-employee basis in terms of what is that employee doing at home. So the Treasury guidance says that funds can be used to provide paid sick and the expanded FMLA leave under the Act. So if you have an employee who's home for one of those statutory reasons and they're not working at all, they're unable to work because they're caring for a child and you're paying them under the Act, the Treasury guidance says, yes, that is an allowable use of the funds. But if they're at home and they're working and they're substantially dedicating their time to COVID activities, then it's just like the last question that I discussed with Anita. Well, then yes, they're substantially, responding, using their time to respond to COVID related issues. If they're at home just doing their normal jobs like they would day in and day out, they're an accountant and they're still reviewing the general ledger or keeping the books or something like that, then probably not, because then their job functions have not really changed. Their just location of where they're doing them has changed.
I see. Okay. All right. Well, I would go to this next question then. And I know Anita had previously talked about the guidance that refers to allowable costs under a payroll support program. Have you heard of such a plan before? And can you explain how a tribal government could create a payroll support program and have those costs be allowable?
So I always go to the easy example, which is what is happening near home. And I live up in Alaska. And so I have heard of such a program. For instance, the legislature of Alaska created a new state grant program for small businesses where states are supposed to give out grants for operating expenses. It's similar to the Small Business Administration Payroll Paycheck Protection Program. The state has said implementation right now is still being worked out, right? So the law was passed, but they haven't figured out exactly how you're going to apply and get the funds and all the details. But the program itself has been created. I think a tribal government could just take a similar step. If they think they're going to have the funding available, then write a tribal ordinance or a tribal law or tribal resolution, whatever your means are of enacting tribal statutes that creates some sort of program and creates eligibility criteria on which tribal businesses are going to be eligible maybe if there's a limit on how much that they can request or how requests will be evaluated. But you can create a similar type of program, either modeled on the PPP or a similar type of idea.
Oh, all right. Interesting. All right, kind of moving on here. I know we have a few more thoughts here on this, on some of the inconsistencies that we've previously discussed. And I just wanted to get your thoughts on this guidance. Do you see any inconsistencies that you want to respond to?
Yeah, so I would say, there's things that might appear to be inconsistencies, and what they really are gray areas, right? So you have a few of these terms. What does it mean to be substantially dedicated to responding to COVID? That's kind of open to interpretation, and some of those, it's important though, because if you're substantially dedicated to responding to COVID, now all of a sudden you can use CRF funds to reimburse those employees' salaries, but if they're not, then you can't. And so there's a lot of like I said, there's a lot of parts of this that are still open to interpretation. Similarly, this idea of a different use, is the employee being put to a substantially different use. What exactly does that mean? And like I said, it's open to interpretation. There likely will be more Treasury guidance, like they have announced that they do plan to release a Q&A next week. There's also been some discussion on a tribal-specific Q&A. I know there's been a request made through Tyler Fish, who's a part of one of the White House liaisons, and now the new executive director of the White House Council on Native American Affairs, about tribal-specific considerations and specifically giving tribes more flexibility. Now, it's not guaranteed that that's going to happen, but he said, great, tell us what your issues are and we'll consider whether that's necessary. So it's at least a possibility that there might be tribal-specific guidance that comes out. We just can't say right now. But I do anticipate that the states and local governments are struggling with a lot of these same questions, and so there likely will be more from Treasury.
Interesting. Okay. So, given the state and local governments, and the fact that really they weren't required to provide, the certifications that tribes had to. And again, the state and local governments have also received their funding already. Do you think there will be any additional lawsuits against Treasury on the way they handle the allocation and the timing of this overall distribution of funding?
It's possible. I think Treasury right now is probably everyone's favorite punching bag. Regarding allocation or who is eligible for that allocation, I don't foresee additional separate lawsuits being filed. As you know, 3 lawsuits that represent a number of tribal plaintiffs have been filed, and all of those have been consolidated, which means they've been put together and they're functionally being treated as one lawsuit. So I don't see another lawsuit coming about that's going to go in front of a different judge. If something else gets filed, I think it's all going to be consolidated so these issues can be dealt with at once. That said, the litigation is not over, and it's actually just at its very infant stage, right? So there's a preliminary injunction granted, but now the parties are going to go on and brief the substance, the heart of the matter, the heart of the dispute. And I do think that there's likely to be more amicus participation. There was quite a bit at this preliminary injunction stage. I think that will continue. I think it's possible that certain parties may decide that they want to intervene in the litigation, which means they would formally join the litigation as a party. So you may see more players in this one lawsuit that's already open, but I don't foresee a totally separate matter going on. Regarding the timing, I guess it's possible, but the lawsuits aren't really likely to go anywhere. A lot of times there's these deadlines, but they're honored only in the breach. And in terms of what would the relief be? You Treasury, you missed the statutory deadline. So what? So you need to release the funds now. Well, by the time that lawsuit actually got filed and in front of a court,
they're probably going to have distributed the funds, so it's going to be a moot point. So I don't see lawsuits on timing as something that we're likely to see.
Okay. Well, thank you for your feedback on that, Becca. That's very, very helpful here. Appreciate it. So we want to go ahead and get started here talking about, kind of change gears and talk about these tax credits and loan options that are available to tribes and tribal businesses. Now, please, everyone, stay tuned here because there's been changes as of recently as this morning. So we're going to hit up on those a little bit here. But the first thing I want to focus on is the Families First Coronavirus Response Act, which was, phase 2 funding, and it seems to get overlooked by the CARES Act. But just real quickly, in a broad summary, there are really two parts to this. And really the first part is the requirement, which is essentially requiring employers to provide sick leave to employees that are either quarantined or have COVID-related issues. Now, most tribes and their businesses already offer their employees sick leave prior to this act, so this really shouldn't be a significant burden for many. However, the second part of this act requires the federal government to reimburse employers for providing this leave that's applicable to COVID-related issues and required quarantines to employees through tax credits that we'll talk a little bit later about. But just real quickly here, the requirements are that employers need to provide at least 2 weeks of sick leave for COVID-related quarantine or symptoms. But then also the act does expand the Family Medical Leave Act to provide up to 12 weeks of leave for employees dealing with COVID-related issues and other issues with kids staying at home or families that are struggling with COVID. Those are the broad basic requirements of providing leave. But it's really important to note that the requirements apply to all tribal businesses that are below 500 employees. But this requirement, now, not necessarily the credits that, again, we'll talk about here shortly, but the tribal governments are required to provide this leave as well. It doesn't matter how many employees, so just keep that in mind. So moving on now, let's talk just real quickly about the tax credits. And now it appears that tribal businesses, including casinos that are below 500 employees, can take these credits. And we've heard of some interesting ways that tribal businesses are trying to maximize this credits. And again, I want to talk a little bit more about that specific example with Becca here shortly. So we'll table that. But you can claim this credit by accounting for that sick leave provided by the quarantine or COVID. And for the most part, you're going to get 100% reimbursement for that leave, which you claim through when you file your Form 941. Now, there's other ways of claiming that, but that seems to be the most preferable method right now by the IRS. But they do have a FAQ on this that talks about other options. And again, finally, the credit does seem to apply to tribal businesses, but it's unclear as to whether it applies to tribal governments, and we'll talk about that here shortly. Anita?
Thanks, Ryan. The other type of tax credit available is it provides relief on qualifying wages and health plan expenses that were paid to employees between March 12th and through the end of this year, through December 31st. And it also includes, because it includes health plan expenses, it would also include furloughed employees that are receiving health benefits. And the tax credit is up to $5,000 per employee. So, for example, if you have if you have 200 employees, and each employee is getting paid during this time, and I'll talk about the eligibility requirements here next. But if you have 200 employees, the maximum amount of credit you could get is $5,000. So it's $1 million on a credit that you can get on this through this employee retention credit. So most employers taking advantage of this might even hit their maximum by the end of the second quarter of the year. So unlike the Families First Act that Ryan just talked about, there's no employee count limit on this. For employers that have employees that are less than 100, this credit applies to all of their wages. For businesses that are over 100 employees, this applies to wages that were paid to employees for qualifying businesses. And those businesses include either the qualifications are either that they experienced less than 50% of gross receipt compared to last year's quarter, or if they had some sort of partial or full suspension of operations due to government orders that limited travel or group meetings or commerce, such as your state or your tribe's own stay-at-home orders. So this would apply to pretty much all tribal casinos, and it would apply to a lot of tribal businesses as well. And we at this point we don't know if this can be applicable, if tribal governments can take advantage of this employee retention credit. But for those tribal businesses and tribal casinos, they can apply for both of these credits. The credits that Ryan just talked about, the Families First credit, because that covers the leave wages, and then this employee retention credit would cover the qualifying wages and health plan expenses. I would say that you want to weigh the pros and cons between employee retention credit and the PPP loan that I'll talk about on the next slide, because you can't double dip. You can only do one or the other, from what our understanding is as of now. And similar to the Families First credit, the way you would apply for this credit is you'll be applying for it during your filing of your 941, or if you have advanced credits, you have the Form 7200. So when you're doing these cash flow predictions for your tribe, casino, or the tribal business, you should consider these tax credit options that are available that we just went over. And now we'll go over the loan options available. So the PPP loan that we've all probably heard a lot about, that's the Paycheck Protection Program. It applies to businesses that have less than 500 employees and meet the SBA 5 standards. And now, as of just as recently, I believe last Friday, now it also allows for casinos to apply for this PPP loan as well. Again, still uncertain about whether tribal governments can apply for this. So the reason this loan has been so appealing is that it's being portrayed as a forgivable loan. But I would just be cautious about this, because when you're applying for the loan, during that application phase, you'll need to certify it in good faith that this PPP loan request is necessary to support your ongoing operations. And that certification at a later time may be subject to audit. So because the guidance says that the loan may be forgiven, there is no guarantee. And although when you're applying for the loan, some of you may have already applied for the loan and you know what your forgivable portion is, there's no guarantee on that forgiveness. So just be very vigilant about reviewing those loan terms when you're entering into these loans. Consider it to be a loan rather than a grant at this point anyways. And also be cautious, but some lenders are applying this. The SBA has this affiliation rules, and we have heard that some lenders have automatically rejected some tribal businesses because they're affiliated with the tribe, which then makes them being outside of the SBA size limit and the employee size limit. But the SBA rule, the affiliation rule, does not apply to tribes in most cases. So be cautious when you're talking to your lenders about it. They might need some education on it as well. And then the big question here is for casinos and other tribal businesses that are applying for this, that are getting a PPP loan. The accounting profession is still evaluating how to account for this, because this is a federal loan program. So although it's a debt, and the accounting considerations for a loan is pretty straightforward, because it's a loans program. If a casino or tribal business spends over $750,000, uses more than $750,000 as a PPP loan, they could be subject to a single audit, where most tribal businesses and tribal casinos aren't used to having a single audit, and they don't have the controls surrounding that. So there are questions that the AICPA is still pondering, and as soon as we have information on this, we'll let you know about it. The second loan option that's available under SBA for tribal businesses, again, including casinos, but uncertain about tribal governments, is the Economic Injury Disaster Loan Program. This one is, this loan is a little more flexible than the PPP loan, because the PPP loan only covers payroll and then a portion of the rent, utilities, and interest of existing debt. But this covers other debt payments. It also covers other bills that can't be paid because of this loss of revenue. The loan terms for this loan, although they're favorable, this loan is not forgivable, so it doesn't seem as appealing, or maybe hasn't been as advertised as the PPP loan. The only portion that is forgivable is the loan advance. Under you can request up to $10,000 of loan advance, and that will not have to be repaid. So those two are the loan options at PPP and EIDL. These two are the loan options that are available to small businesses. And now Ryan will talk about loan options for entities that have over 500 employees.
Thanks, Anita. So the Title V loans, and this is something that, again, has changed as of this morning. All right, this Title IV loans are really for mid-sized businesses to provide stabilization for essentially employees above 500. Now, they've now provided recently, the last few weeks, the types of vehicles or facilities that they'll provide these loans under. So the Main Street lending programs, and there's a few of them depending on existing loans or new loans, this has been updated as of today. Now, the loan is meant for businesses of actually to a maximum of 15,000 employees, not the 10,000 that we have listed here on this slide. But the more incredible thing about this is now the FAQ and the term sheet do indicate that now this is applicable to tribal businesses. So, including casinos. They don't mention casinos, but they do talk about the fact that tribal businesses are eligible. So great clarification that we finally got in the Title IV. So really good to see that. Now, the other portion is a municipal liquidity facility, which they have their own term sheet as well. And this is meant for states, counties, and cities with certain populations. Now, again, I want to talk a little bit more with Rebecca about this here shortly, but tribal governments may fall under the definition of a state to obtain this type of funding, but it's not clear. So we'll wait to talk with that with Rebecca and get her take on that. So just real quickly here too on this third bullet, the loans are not available yet. It's not clear. It's likely to be early May. It could be as early as tomorrow. So be on the lookout for that because Treasury should be releasing some guidance on, those eligible lenders. However, it will not be provided through the SBA. And I want to be very clear about this, that these loans are not forgivable. They do provide very attractive interest rates and various other terms, but it's not going to be forgivable. And just another real quick matter that the FAQ had mentioned is that even if you do get a PPP loan, you can still receive these loan fundings as well. So good to hear about that. All right, let's then get with Rebecca here and get to some of our questions. The first question, Rebecca, and kind of going back to when we were talking about Families First, do those employer credits and even the employee retention credits under the CARES Act, do they apply to tribal governments?
That's a great question. And I'm going to go through these because they're different statutes, so one by one. When you look at Families First and the tax credits, do they apply to tribal governments? We don't know. And I wish I could tell you yes or no. But the response from Treasury, who would be granting the tax credits, has been tribal governments can get the tax credits if they are required under the Act to provide the leave. But we don't know if they're required under the Act to provide leave. That is something the Department of Labor will make a determination on. And up until now, the Department of Labor has not made that determination. They did issue some guidance that they thought would clarify it, but it really did not. So, and they're going to have some determination at some point in time. Whenever we've asked, when is this coming? People in Treasury and in Labor, they can't give you a date. They don't know. But at some point, there will be some guidance there. In the meantime, we've looked at, well, how would a court interpret this statute? And generally, first of all, there's an exclusion for federal, state, and local governments. They cannot get the Families First tax credits. But tribal governments are not listed there. So we don't think that exclusion applies to tribal governments. So the question really is, are tribal governments required to provide leave under the Act? And that that's not clear. Like I said, Labor is going to make a determination. in the statute itself talks about different types of entities. They talk about private entities, they talk about government entities, and they talk about any other entity that is not a private entity. And so we think a reviewing court would look at that and say, well, that is what we call a generally applicable statute. That's a statute that's meant to apply to all types of employers, including tribal employers. That doesn't necessarily mean, though, that it applies to tribes. In most circuits, and there's a little different in case law, they follow what's called the Coeur d'Alene standard. So then they look at, well, is the law something that touches on inherent rights of tribal self-government, or does it fall into certain other exceptions? And so it may depend on, are you talking about your law enforcement employees, or are you talking about your health clinic employees or other employees? And so I think with tribal governments, it's a really hard question to say, does it apply to them? Because you'd have to go through that analysis, and in the end, we've been told, I can go through the analysis and tell you what I think as a lawyer, but in the end, labor is going to make the call. And so it's not clear. On the employee retention credit, again, there's an exclusion for federal, state, and local governments. But again, tribes aren't listed in the exclusion. So can they get the credit? Yes, but, and here's the very important but, they have to meet the other eligibility criteria in the Act. And that eligibility criteria speaks on an employer, quote unquote, carrying on a trade or business. And so there's a question of, are governments carrying on a trade or business? If it's a tribal business, I think the answer is yes, of course. But is the government entity in itself carrying on a trade or business? I think that's where you might have some issues there. And Treasury held an employee retention credit call, I think last week, and they also kind of flagged that language, but again had not stated where they felt the proper answer was. They're still looking into it.
Wow, yeah, it gets complicated. Thank you, though, for that perspective, Becca. Just really quickly moving on here, too, on the second question, going back to Families First, the tribal businesses can get reimbursed for sick leave paid to employees due to COVID. However, if a business is still paying their employees, but those employees are at home due to the required stay-at-home orders, can they call those salaries essentially a sick leave and get reimbursed through the Families First tax credits?
So maybe. And again, this goes back to what the employees are doing. If they're not working, do they meet the other general guidance in Families First for getting sick leave? Are they caring for a sick child or a sick family member? Are they experiencing symptoms of COVID? Have they been subject to a local or state quarantine or isolation order? Right? There's 6 types of events that trigger the ability to get sick leave under the Act. So if one of those applies, then yes. If not, then it's probably going to be treated just like your normal paid time off situation. And then it's going to depend on your funding source about whether funds can be used. So, is it a compact or contract funding source? Then you have maybe more flexibility. But if it's a grant funding source, does the grant allow for that? And then again, you have to look at, in recent months, there's been a lot of federal grants, at least, that have waived certain requirements or allowed for more flexible use of grant funds than they otherwise normally would. So again, you have to look at the employees and whether they could qualify for one of the special types of leave under the Families First.
Okay, I see. Yeah, interesting example there. It requires a little bit more digging in. But just finally on this third question here, is there any concern that tribal businesses, including tribal casinos, would not be eligible for any of these credits that we've been talking about?
So I think there's a lot less concern with tribal businesses than there are with tribal governments, right? When you're talking about the employee retention credit, as I stated, where I think governments might have some issues is with this idea that they're carrying on a trade or a business. Well, a tribal business is carrying on a trade or business, so they don't have that same issue. When it comes to the Families First leave credits, are they required to provide leave under the Act? Well, now you're not looking at, does it apply to a tribal government? You're looking at, is the business a private entity, or are they any other entity that's not a private entity, right? So it's more likely that they're going to be required to provide the leave, and if they're required to provide the leave, then Treasury has said they can get the tax credits. So I think in that context, again, this is based on what we know now, and subject to additional guidance from Labor and Treasury, that they are more likely to be eligible for the credit.
That's good to hear. Absolutely. Thank you, Becca. And Anita, you had some questions.
Yeah, so I talked about the SBA PPP and the EIDL loan options that are available to casinos and tribal businesses. Do you know if tribal governments can apply for these loans, these SBA loans? And what about those tribes that have businesses under the tribal government's EIN number?
So I think it's unlikely that a tribal government is going to be found eligible for either the PPP or the EIDL. And the reason I say that is because both of those programs refer to a quote-unquote tribal business concern. And so the government itself is not a business concern, but a tribal business likely is. And the definition of tribal business concern is actually tied to language in the Small Business Administration Act. It's something that's wholly owned by one or more Indian tribal governments, or that is owned in part by one or more Indian tribal governments. So it's very clear that the tribal business concern is speaking to the business entity, but that term does not refer to the actual government itself. In terms of what if the business uses the same tribal government EIN, it's very interesting because, like I said, there were some calls last week with SBA and IRS, and both of them are part of Treasury. And the IRS representatives on the call said how you file your taxes in terms of what EIN you use, from their perspective, doesn't impact whether, the tribal business is part of the tribal government. And however, SBA on their call seem to be more concerned with this issue. Treasury knows that this EIN question is an issue. They haven't yet issued guidance about their usual aggregation rules and how they're going to apply to tribes. So I think that in theory they should be eligible whether or not they're using the same EIN. Again, on this same rationale that IRS has, how you file your taxes doesn't define what type of entity you are, but it remains to be seen kind of how that's going to be interpreted.
Okay, that's helpful. And then, as you know, casinos only recently became eligible to get a PPP loan, like last Friday. So, the employee retention credit, that's for eligible, the time frame is March 12th to December 31st of 2020. But all the guidance that we're hearing is that if you have a PPP loan, you can't get an employee retention credit. You can only do it's an either-or option. But can a casino or a business apply for? Can they use the PPP loan and the employee retention credit if they cover different wages?
So Treasury has answered this and said no. They said being eligible for the PPP loan doesn't change anything. But if you actually take the PPP loan, if you get it, that disqualifies you from any part of the employee retention credit, no matter when taken. So if you get the PPP in mid-April or mid-May at this point, you can't claim the employee retention credit for the period before that time.
That's unfortunate. Well, that's what Treasury says. So, is there a downside of using the PPP? So, for example, if individuals were let go or furloughed before the PPP was approved, can they be rehired by June 30th and not be penalized for that?
Yeah, so these are actually two separate questions. One is there a downside? Well, we just talked about one of the downsides, right? If you take the PPP loan, you might not be eligible for other credits, such as the employee retention credit. The other, I guess, downside or concern for people to think about is you might not qualify for full loan forgiveness if you don't meet the terms of the PPP loan, right? So you have to maintain employee compensation levels. You have to use a certain percentage on payroll costs. That may be simple for you to meet, or that might be difficult. And if you don't meet those requirements, then you will not receive at least full loan forgiveness. In terms of what if you've furloughed employees, can they be rehired? Yes, you just need to rehire them by June 30th if you want to be eligible for the full loan forgiveness. There's an exemption for employers that reduce employees between February 15th and 30 days after enactment, as long as they're rehired by June 30th. Now that's important because 30 days after enactment is, I think, April 27th, 26th, maybe, 31 days in March. So, so if you today's April 30th, if you furlough a bunch of employees today, that could be problematic. But if you furloughed employees earlier, then, and you rehire them by June 30th, then you should not have a problem. You should not face a penalty.
Okay, helpful. Thank you, Becca. So Ryan has some questions on Title IV loans.
Mm-hmm. Yeah, Becca, we're just peppering you with questions now. But, you know, just really quickly on this first question here. Oh, thank you. We know now, as of this morning, that tribal businesses can obtain the Main Street Lending Program loans. But what about that municipal liquidity facility for tribal governments? Can tribal governments be eligible for these Title IV loans?
Yeah, and so I was going to say both governments and casinos could be eligible, but from different lending facilities, right? So if you're a business, you're going to go towards that Main Street lending facility. If you're government, then there's a municipal lending facility. And this is something to pay attention to. In almost all instances, when Congress uses the word state, they don't mean tribal government. But in this particular part of the CARES Act, there's a definition of state, and it says the term state means any of the several states, the District of Columbia, any territories, any bi-state or multi-state entity, and any Indian tribe. So just for this specific instance, we're going to go against the normal rule and say that governments, like states, can qualify for loans.
That's great. That's great to hear. You know, kind of moving on to this next question, you know, these Title IV loans and these various programs do have some eligibility requirements, one of which is that the business can't pay out dividends to its stockholders. And so, you know, we've had a lot of questions about that. And, you know, given the fact that tribes are not providing dividends, they are providing distributions in the form of per capita distributions. Would that be considered a dividend under the requirements here?
Likely not. And I say that because if you look in the tax code normally, it treats per capita distributions differently than dividends paid by a corporation. Because per capitas are paid by a tribe, they're paid by a governmental unit. And if you look at section 4003 C2F, which is part of the CARES Act, it speaks to quote unquote capital distributions with respect to the common stock of the eligible business. When you're looking at per capita casino distributions, that's not from common stock, right? It's not a publicly traded business. That's not how that works. And so you're really talking about, when they talk about dividends, they're talking about something that's of a very different nature than a per capita distribution.
Oh, that's good to hear. That's very clear. Thank you. And then just real quickly, finally, what are some of the other impacts of that most recent act passed on the 24th to tribal governments and their businesses?
So the main points of that act is there's more money for the Paycheck Protection Program. And now that it's been clarified that tribal casinos can apply, even though they couldn't get first round funding, they might be able to get second round funding. So it's good that there's funding available. Again, these loans are on a first come, first serve. There's a very long list of people waiting to get their loans actually processed and completed. So if that's something that you're interested in, get your applications in yesterday. There's also more money for the EIDL, again, subject to the same restrictions that you went over. And then there's some more money for healthcare. So there's $25 billion for testing, and this is really part of a push to set up a comprehensive testing program. So these funds have a fairly narrow use. There is a set aside for tribal entities. So there likely will be amounts distributed to every tribe or tribal health organization, but it's specific for testing and really trying to get to the point where we could have like a universal testing program. Then there's quite a bit more money for provider relief along the lines of the HHS Provider Relief Fund, and these are going to healthcare facilities, whether it's hospitals, clinics, whatever the facility type is, but it's funds for facilities to stay in operation. And some of this can be used for lost revenues, to replace lost revenues. Again, there is a tribal set aside in those funds as well.
Great to hear. Thank you. Anita?
That was super helpful, Becca, especially for some of our tribal health facilities that are losing out money on their third-party revenues right now with elective surgeries being pushed out and everything. So I only have two more questions for you. Do you expect any additional stimulus funding that will be made available to tribes?
Possibly, but I think if you see more funding, it's going to be targeted, just as the funding in the, what I'm calling the PPP HCE, right, the April 24th Act is. It's not going to be, here's funds with no strings attached. It's going to be, here's more funds for testing, or here's funds for health providers for unreimbursed healthcare expenses or lost revenues. There has been a push basically to increase the COVID relief fund for states, tribes, and localities, but the word on the street is that's not very popular with Republicans, especially because they want to see with the first, large sum of money that's going out, once it's out, how is it actually being used? And especially with the narrow Treasury guidance, I think it's going to be, I don't want to say it's going to be difficult to spend the money, but I think that it's not going to be something where people get the money and can spend it all down in a day, right? Because they need to make sure that they're checking those very narrow boxes. So whether that gets increased, that's kind of right now subject to politics, and we'll see how that goes. It's possible in the next round to see more funds for like SNAP benefits, supplemental nutrition, or critical access improvements. But I don't think there's just going to be open-ended kind of general type funds that you're going to get.
All right, and I know we're really short on time, so I'll make the last question, my last topic, really quick. Who can people ask for advice on these issues?
So the two main people are your lawyer and your accountant. And like I said, a lot of the questions right now are in gray areas. They require nuanced analysis. Sometimes it's an employee by employee analysis, department by department, and so it's really incumbent that if you're not sure that you ask someone to do that type of analysis and to think through it, because it has been made clear that if funds are not spent on their intended purposes, Treasury plans to recoup them. They want to be paid back, and what would be even worse than where you are now is to be sitting December 30th or, in January 2021 with a request from Treasury to pay back millions upon millions of dollars.
That's a very good point. And thank you so much, Rebecca, for joining us and for all of your great insights on this. I will very quickly go over certain compliance matters. As you may have noticed, that most of the tax credits and loan options, other than the Title IV loan that Ryan discussed earlier, provides funding options to tribal casinos and tribal businesses. So then the remaining two funding options available to tribal governments is that $8 billion pot of the Treasury funding that is yet to be dispersed and the additional grants that are appropriated under the CARES Act. I'm sure most of you have either heard about or read through the OMB memo M2017, which was directed at federal agencies for the purpose of providing relief to grant recipients. However, individual federal agencies have provided various conflicting guidance on these matters. So the AICPA and the GAQC, the Government Audit Quality Center, has submitted a really thorough letter a couple weeks ago to OMB to provide guidance on how to approach this funding. The only things I would say right now, the biggest things, is that please make sure you're tracking all of the COVID-19 funding separately, and that you are evaluating what the period of availability is for each of these fundings compared to your existing grant awards, and try your best to use that COVID-19 funding first, because they may have a shorter availability period than your other grants that may be available until extended or until have much lengthier availability period. We know many of you need to change your source of funding for various employees. Please make sure you're just documenting this either in your PAFs or other alternative ways, documenting your justification of why you're changing your costs or any costs that you're charging to COVID-19 related items. Lastly, GASB has considered delaying the implementation of those larger standards, the fiduciary and lease standards, and they'll make a final decision on this on May 26th, and we'll let you know when we hear about that. But in the meantime, that is all we wanted to cover, but if you have any questions, there are resources available on Moss Items on our website, and you can always reach out to us. Pam?
Yeah, thank you, Becca, Anita, and Ryan, for a great presentation today. If you have other questions for our presenters, you may reach out to them directly using their contact information in the speaker bio widget, and it's also included here in the slide deck. We know that there are several questions that were submitted today, and if we weren't able to address your questions this morning, we will be reaching out to you shortly. For more resources, please visit our Moss Adams COVID-19 web pages. You can also find these links via the slide deck and handouts widgets to the left slide view. Also, today's webcast was recorded, and we will be sending a link to the recording as soon as it's ready. And then finally, here is a link to an online survey where you can provide feedback for today's presentation. Please take a moment to complete this survey, as your feedback is very important to us. Thank you again for joining us, and we hope you'll join us again next time.